Wisconsin coverage of the April 3 election for a term on the state Supreme Court continues. We're interviewing Sauk County Judge Michael Screnock. And Judge, thanks very much for coming in.
Well, thank you for the opportunity. I really appreciate it.
You're seeking a 10-year term on the seat now held by Justice Gableman, who's not seeking re-election.
That's exactly right. He announced back last summer that he's not seeking re-election, and I thought the time was right for me to step up.
Fascinating background. You spent 12 years in local government, went back to law school. Then you worked for the Michael Best firm, and then you were appointed judge in 2015.
That's exactly right. You know, and it really is, you know, the experience that I had is a full experience, and it really prepares me well for the Supreme Court. When you think of the work that the court does, many of the cases that come before the court have at their core this tension between private interests and society's interests as those interests are reflected in regulations. And so when you look at my career, I spent the first nearly 12 years in local government assisting city councils and mayors.
It was interesting. Reedsburg, Washburn, and Ashland.
Absolutely. 3 small cities in Wisconsin, one in Sauk County, one in Bayfield County, and then of course Ashland in Ashland County as well. My role there was really assisting the city council and the mayors in understanding the limits of their lawful authority and then helping them accomplish the goals that they had within that authority. With my work at Michael Best, I then represented private interests in their interactions with government, both state and local. And so I was involved in that, again, that tension between private interests and society's interests from both sides. Now as a judge, I don't have a dog in the fight. As a judge, my fidelity is to the law and to the law alone, and not to either side that comes before me. And so with that experience, I really do believe that I'm well prepared to serve on the Supreme Court.
After 12 years of local government in Wisconsin, where you're a native, why did you go back to law school?
You know, it was just a discussion that my wife and I had over the course of about a year. I think deep down, my passion always was with the law, and I just chose, after I finished my bachelor's degree, to pursue a master's in business administration rather than law school in my early 20s. And at that time, I kind of thought that I had foreclosed the notion of being an attorney. And then I really enjoyed my work in local government, but really the passion for the law kept pulling me towards law school. My wife and I talked about it. We have 3 sons. They were in the ages of between elementary school and middle school at that time. And at first I laughed at the notion. I thought, well, this couldn't possibly work. And then the more we talked about it and prayed about it, it became clear that it was something that we could pull off as a family. And so I then went back to UW-Madison for law school, and was able to get through in 2.5 years, which was really important for our family to get me out of law school and back into the workforce.
That's a very interesting transition. What's the biggest change you've learned now that you were a judge? Because you were an attorney with Michael Best, and then the governor named you in 2015 to be a Sauk County judge. Biggest thing you've learned on the bench?
Well, the biggest thing I've learned on the bench is really the issues that people face that live lives different than well, for me, the life I'm used to, but for all of us, you know, we live a life, and we have friends and acquaintances, and we sort of understand that sphere. I've been privileged to preside over Sauk County's drug court since its inception. We started it in January of 2016, and to see the participants in our drug court week after week, especially for the first 6 or 8 months, I see them every week. To see the struggles that they go through in trying to break through the addiction, and to understand in a very intimate way the lives that they're living and the struggles that they're wrestling with really helps me understand their concerns and helps me understand the issues that we're facing right now with our opiate crisis across the state. And not just opiates, but up north, it's the problems are with meth more so than heroin. You know, it really has been really interesting. It's been a real privilege to see life through the lens of their eyes and to see the struggles that they face.
Well, that's interesting with the heroin and opioid epidemic. What's your success rate on the drug court?
Well, we're very new. We've actually had only one graduation. As I said, we started in January of 2016, so we've been going not quite 2 full years, actually this week we might hit the 2-year mark. So we had a graduation back in September. We graduated 3 individuals. We have another one. Looks like we may be scheduling another one for late February.
What does a graduation mean in terms of the drug court?
Yeah, that's an excellent question. Right. So treatment court is between an 18-month and 2-year process where our participants go through treatment court. Graduation means that they're done with our program. And there's actually a real question within the treatment world whether we should even call it graduation, because it really is just their next step in their path to sobriety long term, to achieve and maintain sobriety long term. We call it graduation because we think it's important to recognize they've done a lot of hard work during those 18 to 24 months. But what really changes when someone completes our program is that the intense oversight that we provide through treatment court is then done. And so during the last couple phases, the last, say, 4 to 6 months that they're with us in treatment court, we really try to wean them off of the services that we're providing in terms of how frequently they meet with treatment professionals and with our case coordinators and with the probation agent, to try to get them to where they're building their own private network of support that they can then rely on once they've completed our program.
What has happened to the criminal charges that brought them into your courtroom in the first place? Are they held in abeyance, or?
Not exactly, no. And there are 2 ways of doing that. What we've chosen in Sauk County is that everyone who is in treatment court has already been convicted of a crime and placed on probation. And then participation in treatment court is a condition of their probation. And it's a little inside baseball. The reason we do that is because that then brings to our treatment court team the probation agent as well. So that's one more player, one more resource that we have during our treatment court experience to rely on to assist the participants in getting all of the services that we can identify that they need.
Okay, let's move to the Supreme Court race. What do you consider the top 2 issues in this race, sir?
Well, I think the most important issue in the race are the candidates' judicial philosophies. And I believe strongly in the rule of law. I believe strongly that the role of the court is to interpret and apply the law as it's written, and not to bring to the court's decision-making the justice's individual policy preferences or personal beliefs. And when justices don't do that, when they don't exercise the self-restraint necessary to set aside their personal beliefs, you end up with an activist court, and you end up with a court, what I like to say is a court that's results-oriented, that takes a case and the justice says, well, this is where I want it to end. Here's the beginning point. Now I'm just going to find a path to the result that I want. And I think that's wrong. I talked with Justice John Wilcox last summer, and he said, when I was on the court, I did the research. He said, you do the research and you go where the law takes you. And I thought that's a very clear, succinct description of what I believe the role of a justice is. You do your research, you determine what the law says about the complex question in front of you, and then you make your decision based on the law, not based on what you wish the law said or was. And in my work at Michael Best and Friedrich, that's what I did. I did a lot of appellate advocacy. I was involved in 12 or 13 cases in our court appellate system. A number of those cases went beyond the Court of Appeals and on to our state Supreme Court. And in doing the work for our clients of wrestling with those cases and doing the research necessary to brief the cases, I was doing the same research that a Supreme Court justice needs to do, because I had to look at this question from all angles, try to identify what would be the strongest arguments for our opponents, and then to be able to articulate what we believe the law was saying about those cases and try to convince the court that our client's position was correct. So I did that work for years at Michael Best and Friedrich, the very work that the Supreme Court justices do when they're wrestling with these same types of problems.
You're seeking a nonpartisan office, but you're perceived as the Republican candidate. Do you want to talk about that?
Sure, yeah. And I appreciate your description of it, that it's a perception. Because as I said, I believe strongly that the individual justice's personal beliefs, their policy preferences, if there are any, don't matter and should not matter to the work of the court. Now, what we have in Wisconsin, a couple of things have happened. First of all, you'll remember from the mid-2000s, after Justice Sykes was appointed to the 7th Circuit Court of Appeals and went to the federal bench. That's when Governor Doyle appointed Louis Butler on our Supreme Court. And at that time, then we had sort of a changing in philosophy on the Supreme Court, and we then had 4 justices that I would say felt less tethered to the law, and there were a number of decisions that came out somewhat in rapid-fire succession that lots of people in society viewed as being activist decisions. And indeed, that's what compelled Justice Gableman to run in 2008, 10 years ago, to try to get the court's focus back on just following the law. What happened during that time is people in the state sort of woke up to the risks and the dangers of having justices on our court that really do feel empowered to impose their own personal policy preferences on the state through the court's decision making. So what happened? Money flowed in. Why did that happen? Money will always follow power. And if Wisconsin is viewed as a state that empowers its Supreme Court to thwart the will of the people as expressed through the legislature or through the governor's office, through our 2 political branches, if Wisconsin is viewed as a state that allows its court to assume power to overturn those policy decisions, of course money is going to flow into these elections because those that are interested in the policies that are set for the state will want to be part of the decision-making process. Now, you can't do that on the court. And it's one of the unfortunate realities of the way this race has been framed. Both of my opponents are critical of the current makeup of the court. They are articulating publicly that our court is broken, that our court isn't independent, that it isn't nonpartisan. Those are serious charges. They really are. And quite frankly, those charges go to the very heart of our judicial system. If you read our code of conduct, our judicial code of conduct, the preamble talks about an independent and an impartial judiciary that decides its case without prejudice for any reason, race, religion, socioeconomic status. Everybody that comes in front of the court gets a fair shot, and they stand on equal footing in front of the court. That's fundamental to our judicial system.
You mentioned that money flows to these races now more so than ever. Well, let me ask you about the petition that said if a Supreme Court justice or a candidate got X amount of money,
right,
he or she should step off a case.
Yes.
Do we need a rule like that, sir?
Well, I don't believe we do. First of all, we do have a recusal rule, and I think it's important that people understand that. It actually has multiple sections to it. I abide by it, and I actually implement it frequently. Just the other week, I recused from a couple of different cases.
Do you give a reason for stepping off a case? Because Supreme Court justices do not have to, as you're aware.
That's an interesting point, because I do give a reason, and in fact, the form that we fill out as circuit court judges has us identify, at least in general terms, a reason. I don't usually give paragraphs. And there are concerns about that. Now at the Supreme Court, I can imagine there might be. Here's what I think, and I haven't spent a lot of time thinking about would I give a reason or not. One of the realities of our Supreme Court is that you have no bench players. We have 7 Supreme Court justices, and that is the court. And if one of them steps off a case, we have 6.
There's no provision.
There is no provision for any fill-ins, for any substitute justices to sit on a case. That's not the case in the circuit court. We have hundreds of circuit court judges, and we can go through and pick, bing, 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 until we get to one that doesn't need to recuse. So that's a reality that can't be lost. And I say that because one of the things that I can see as being a concern about justices giving too much information about why they are recusing from a specific case is that it could, over the course of a 10-year term, it could give litigants sort of a playbook. Oh, if I want to knock this justice off because I think I don't like the way he or she might rule in this case, here's the dossier on what has caused him or her to decide to recuse in the past. Now let's see if we can work on that. And I think that's a danger because it's important that that when justices can remain impartial and decide cases without being beholden to any outside influence or being swayed by any outside influence. I think we want them all there. We want them all sitting on a case and deciding a case.
So you wouldn't adopt any financial trigger if your campaign received X amount of money from any lawyer or principal or organization before the court. You wouldn't step aside automatically just because of the amount of money donated to your campaign?
Yeah, I don't support a rule that sets a dollar trigger. And this actually came up in Justice Abrahamson's last run in 2009. There were some attorneys who had donated to or contributed to her campaign, and her opponent asked her to recuse herself or announced that she would recuse herself on any cases where those attorneys were representing a client. And she was asked that question, and she defended our current recusal rule. She said, we have a rule, and the rule that we have causes and requires a justice to look at all of the circumstances of a case in deciding whether or not they can be fair and impartial on the case. And she said it twice for emphasis, all of the circumstances.
Has your campaign put any limit then on how much you'll accept from any organization, or have you established, there are other limits? Candidates for governor have said nobody can give me more than 200, but you don't have any limits like that.
Well, we haven't artificially capped and created any limit that would be below the campaign finance laws that provide limits.
Understand.
But I do want to say this about the recusal rule, because we have two things really in tension here that both are important. First is we have an elected judiciary. That's the system that we have in Wisconsin. We trust the people, we trust the voters to select their justices. That's important. And we also have the First Amendment right of individuals who want to be engaged in those campaigns, engaged in those elections, to have their voice be heard and to articulate to others why they're supporting one justice or another. And what I think is important is that we don't have an artificial rule that would cause individuals who want to engage in that speech to feel that they need to hold back, because otherwise they would not be allowed to have a full bench, a full court, if they happen to be a party coming in front of the court. Okay. So that's why I think the artificial rule that was proposed is not a good one. Okay. And again, Justice Abrahamson, when she was asked this question back in 2009, she said, look, I will not allow someone to disqualify me from a case by making a contribution. So that's a concern that was raised in responses to the petition, that you could have somebody that could anticipate they were going to have a case coming up, and again, because these terms are for 10 years, and contribute to a candidate that they would perhaps not want to have sit on their case in order to force recusal. Now, the petition addressed that, but in a way that I think is perhaps even worse, because what the petition provided for is, okay, in that circumstance, then your opponent gets to decide single-handedly whether that justice stays on or off. Well, now you've got the opponent who has, under the rule, the ability to pick and choose whether a justice sits on a case. That's even worse.
The court recently closed the administrative hearings. Should they stay closed, or should they go back to being in open?
I have no problem with them being closed as they are now. My understanding is that there's no other state Supreme Court that opens their administrative conferences to the public. And I think, so a couple of things. I think Wisconsin's had done it for about 22 years. So it was, you could say it was a leader in that respect. If it was a really, really good practice, I think we would have seen other courts jump on board and say, hey, that's a great idea. Now, a couple of things about the change. First of all, they didn't shut down public hearings. And periodically during this campaign, people have articulated as the court shutting down public hearings. They hold public hearings. And when they hold public hearings, they're public, and the people can come and watch, and they can speak, and they can address the things. But I think what's important about the court, and it gets into their decision-making as well, is that the Supreme Court is a body. Now, it has 7 members, but it's a body. And when it's deciding a rule petition, the body speaks through its written decision when it either adopts or rejects the petition or adopts it with amendments. And they issue a writing, and they say, this is what we were thinking, and here's why we did what we did. And I think it is sufficient for the public that they hear from the court through that written document, rather than trying to pick and choose what one justice might have said in the context of the members talking about what they were going to do about a petition, and maybe trying to pick up on stray comments from individual justices. And here's why that's important, because remember, we want everyone to believe. It's important that people understand and believe that when they come in front of the court is looking just at the law and the facts of the case in front of them and deciding those cases on an impartial basis. And if you open up those administrative conferences as they were to the public, and the justices actually are speaking frankly to one another, which I don't know whether they were or not when the conferences were open, it allows future litigants, again, more insight into the minds of the justices, what things might motivate them, because when you're dealing with administrative conferences, you're not dealing with cases or controversies. You're dealing with issues that might involve public policy. And so it would again allow that insight for litigants to try to gear their comments and their arguments in briefing to try to pull at the heartstrings, if you will, or those matters of public policy that they think the justices care about. And again, that's not part of the justice's job.
When you were in Michael Best, you worked on two major public policy changes. Why was both the Act 10 change and the reapportionment, the redistricting plan adopted in 2011, constitutional?
Well, I'll tell you, Act 10 was constitutional because it didn't violate any constitutional limit.
Why was it good public policy?
Well, you know what?
As a former veteran of local government.
Sure. I have an opinion as to whether it was good public policy or not, but it's important to understand that that's not critical to the work that I do on the bench right now. Again, as I said, when I was in local government, my fidelity was to the elected officials and the tasks they were trying to accomplish. When I was an attorney, my fidelity was to my clients and trying to advance their interests as best I could through the talents that I had, the law that we had available to us, and the arguments we could put forward. As a judge, my fidelity is to the law. And it doesn't matter whether I think the law that's in front of me is good public policy or not. What matters is, what did the legislature say? What does the law say? And it's not my role as a judge to decide that they made a bad policy choice and therefore I'm going to deviate from the law. I just don't have that authority.
Court of Appeals judges, federal Court of Appeals judges have said the redistricting plan that you work to defend is illegal, and that's now pending, as you know, before the U.S. Supreme Court.
That's right.
Why do you still believe it was legal and justified?
Well, we'll find out soon enough.
Yep. By the end of June, hopefully.
Yeah, I think by the end of June for sure. And so what we had before this year is the Supreme Court has never articulated that a redistricting plan could be unconstitutional based on partisan considerations. So what we do know is that when you look at the redistricting plan from after the 2010 census here in Wisconsin, that the court has said that it met constitutional muster in every respect. I'm trying to be careful. There was an earlier case, and I think they moved one assembly district boundary in the Milwaukee area.
In Milwaukee.
So leaving that aside.
Hispanic population.
Yeah.
So I think they shifted 2 lines, one line. Go
Something
ahead.
like that.
Yeah, you're right.
But other than that, for the case that's in front of the Supreme Court now, the federal panel said that there was no constitutional problem under any of the traditional districting principles. And the question is one of whether or not a partisan basis for creating the district boundaries is unconstitutional. And up until today, the Supreme Court has never said that's a constitutional problem. By the end of June, we'll have the answer. And what I can tell you is this, that if I am privileged enough to serve on our state Supreme Court and the 2020 redistricting plan comes in front of the court, I will follow the law. And we will then know what our U.S. Supreme Court says about partisan influences in the districting process, and I'll follow their instructions.
Another issue are the petitions for what's been called the civil Gideon, the right for a defendant in child support and other fairly minor non-criminal cases.
Right.
to a publicly paid attorney. Your position on civil, Gideon?
Well, I have individuals in front of me all the time on indigency petitions, and we regularly appoint counsel to those individuals. I don't know whether it's a court issue or a legislative issue. I believe it's a legislative issue, and that we haven't yet had our legislature weigh in and say that that it would be appropriate to commit public funds for civil litigants. And again, certainly as a judge, if the legislature speaks, I will follow the law. And at this time, I don't believe I have that authority for the types of civil cases that you described. Now, why is that important to me? Because our county pays those costs. So when I appoint counsel for an indigent litigant, the county actually fronts that money. We direct the individual to reimburse the county at some small rate. They may or may not, the county may or may not be able to collect that. And so it does have impacts on local budgets. And so that's why I don't have the authority to just launch off and direct the county to open up its funds and start paying for attorneys for civil litigants until I'm authorized to do so.
I want to give you a chance to talk about your differences with your opponents. Let's start with what Mr. Burns, one of your opponents, said in a January 8 interview when he sat there. He said, quote, referring to you, 30 years ago, you were out protesting and arrested at abortion clinics. Those are his words, not mine. Mm-hmm. I want to give you a chance to respond.
Well, I haven't plumbed the depths of those words, but in a large fashion, that's true. I was part of a group of individuals that on two different occasions chose to protest, peacefully protest. I mean, when you think of a protest, I don't know what comes to mind, but we went in the early morning hours in front of an abortion clinic. We sat down in front of the front door and we were singing songs. And when the police came and asked us to leave because the owner of the property asked that we be removed, the police came and asked us to leave, and we didn't. And so we remained seated and singing, and eventually the police officers needed to carry us away off the premises. And that was the sum and substance of the protest.
Was that a civil forfeiture, or was there any? How was that resolved?
It was resolved. I was cited for trespassing, and instead of paying a forfeiture, I did community service in both instances, and I did so at one of our local nonprofits here in the Madison area that worked with elderly folks, and so I completed my community service, and that was it. So I don't have any criminal conviction on my record. I wasn't prosecuted for a crime. Mm-hmm. I was cited for trespassing, and did community service.
Do you think Roe versus Wade should be overturned?
You know, I can't overturn it. It's not something that is a state Supreme Court issue. So Roe versus Wade is the law of the land, and I follow it as I must. And so, there is a lot of suspicion out there that because of my passionate feelings about abortion 30 years ago, that somehow that would influence my work on the bench. Until the Supreme Court does something with Roe versus Wade and changes the law nationwide, there's nothing that a state Supreme Court can do to overturn Roe versus Wade.
Would you have to step away from cases involving, say, Planned Parenthood or issues that may directly or tangentially include the abortion issue, do you think?
I don't believe so. Now, it would depend on the specific case. I've not been actively engaged in pro-life causes, other than I've supported one of my high school classmates runs a pregnancy helpline in Michigan. Now, of course, her facility is not going to be a litigant in Wisconsin, I can't imagine. Right. But again, when a case comes in front of me now as a judge, and if I were on the Supreme Court, the question is, can I set aside whatever feelings I have for whatever reason, whether it's because of personal beliefs that I have, whether it's because I had a bad experience. I went to the grocery store and was treated rudely by a clerk. Whether it was a client that I had in the past, there are any number of reasons why I might say, I can't be fair here, and I need to step away. Okay. That's what our rule requires, and that's the analysis I do every day.
I asked you to respond to comments by Mr. Burns. Now it's, what do you want to establish any differences, but as you perceive them between you and your two opponents in the February 20th primary?
Oh, absolutely. I think the differences are clear, and I think the differences are more clear than we've actually seen in the Supreme Court race before. I believe strongly in the rule of law. And what I mean by that is that, as I've articulated, that the role of the court is to interpret and apply the law as it is written, not based on the personal beliefs or political beliefs of the individual justices. The role of the court is to be arbiters of the law, not policy analysts or political activists. And I think when you look at my two opponents, neither one of them share those views. Mr. Burns has called the notion of an impartial judiciary a fairy tale. I think he said it on your program.
That's probably pretty close to what he said.
And Judge Dallett the other day referred to the rule of law as garbage. That was the phrase she used. And then she was talking about me and my commitment to the rule of law. And then she said, let's be real. It's rule of law until you want it to be something else. Well, that's not true with me. And the reason I think that she thinks that is because it is true with her. That both of my opponents are actively campaigning on the political issues that they hold dear. And I think that's distressing because it is not the court's role. It's not the role of our justices to get up on our Supreme Court and decide cases based on the way they want the political issues resolved. That's what our legislature's for. It's what our governor's for. It is fundamental to our system of government that we allow those two branches to be the political branches. They're going to shift with the political ones. They're going to blow and shift as the political winds shift. That's what we expect. That's what we want. The court needs to be the branch that provides stability. And we provide that stability by simply adhering to the law and not by trying to change the law or to change these policy choices that the legislature and the governor have made simply because we as justices don't agree with them.
And that's what's at stake in the April election.
Absolutely it is.
How important is collegiality? That's final question because we're almost out of time.
Collegiality is very important. I have a collaborative leadership style. I've worked with groups, when you think of the work at the local government level, everything is done by committee, and you need to be able to work with others to get the job done. I look forward to working with the members of the Supreme Court. I respect them all, and I see no problem at all with me being able to join that body and really work well with the individuals that are on there.
Thank you. Sauk County Judge Michael, help me so I don't mangle your last name.
Michael Screnock.
Thank you. Is one of three candidates in the February 20 primary, and we've interviewed Mr. Burns. You can look that up at wissai.org. We're scheduled to interview Milwaukee County Circuit Judge Rebecca Dallett on January 30th. Sir, thanks for coming in.
Thank you very much. Appreciate it.
Thank you.